Hey guys. Okay, so I'm just going to start by saying I am going to try and stay off my soapbox while going through this. I think it's going to be a challenge though. So this order from Judge Lyman kind of follows on from his order on Section 47.9, awarding liably her attorney's fees and costs. And it's quite self-explanatory, or so you'd think. So I didn't even bother doing anything about this because I didn't feel like it needed an explanation to people who did not understand the law, the ordinary layperson who's been followed in this case. And the whole, the reason I'm doing this is to explain things that may need explaining. So let's go through it because what followed after this is just the height of ridiculousness. Okay, so from Judge Lyman, the court has issued an opinion and order regarding liability for attorney's fees and costs under California Civil Code Section 47.1. By June 22nd, 2026, Lively shall file papers regarding the appropriate measure of fees, and the wayfarer parties shall respond by June 29th, 2026. Okay. I didn't see a problem there. That is really self-explanatory. I did not feel like, I needed to patronize people who don't understand the law and do a whole video saying, hey, this is what this means. I still don't feel like I need to sit and say, this is what it means. It is quite, it's quite standard. You just need to, Lively just needs to file papers on the fees that she's seeking to recover, and the wayfarer party get to respond to that. Like they're going to haggle basically over whether, Lively's going to say, well, I incurred all these fees, and wayfarer are going to probably come back and say, no, that's too much for this reason and this reason. And then it's got the deadlines for this as well. So Lively has to file her response by the 22nd of June, and wayfarer have then got to respond to Lively by the 29th of June. Okay. That is about as simple as it gets in law. But for some inexplicable reason, Lively's legal team are acting like they're stupid. And have filed a letter basically asking Liman to explain it to them like they're 5 years old. And this shit really pisses me off because they know what they're doing. If they don't know how to deal with, when they've been awarded fees, if they don't know how to then, request those fees, and I don't even know what they're doing here. Part of the reason this is annoying me is because they brought Section 47.1 into this back in March last year. So over a year ago, well over a year ago. And they have been dealing with the fee motion since October last year. And now they've waited all this time. I'm sure they anticipated getting something. They were very confident about it. And now they've got something. They're like, yeah, we're not ready. We need an extension because we need you to explain to us what we're asking for. So I'm pissed off. Anyway, we're going to read this crock of shit from, I think it's Ezra Hudson. Blake Lively writes to request clarification and a short extension on the June 22nd, 2026 deadline the court set yesterday for Miss Lively to file her initial brief on the appropriate measure of fees under California Civil Code Section 47.1 as set forth in the court's order yesterday, June 15th, 2026. Specifically, we respectfully request that the court clarify whether it is seeking briefing on 1. The legal principles for recovery of attorney's fees and costs under Section 47.1, including issues of apportionment, for example, or to the extent to which fees were incurred on issues common to claims for which attorney's fees are provided by statute and claims for which they are not. Or 2, Ms. Lively's motion for attorney's fees and costs seeking a sum certain with supporting materials such as affidavits and billing records and corresponding opposition. Or 3, any other subject. If the brief is primarily intended to focus on legal principles, Ms. Lively respectfully requests an additional 7 days to June 29th, 2026 to submit her initial brief. If, alternatively, the court is seeking briefing both on the legal principles and Miss Lively's motion for attorney's fees and costs, seeking a sum certain with supporting invoices and other supporting evidence as to the reasonableness of fees and costs, then Miss Lively seeks an extension to submit her initial brief until 30 days from June 15th, 2026, or until July 15th, 2026. Oh my god. I don't understand why she needs all that time for invoices that they've got to be ready to go by now. Under Federal Rule of Civil Procedure 6B1A, a court may extend a deadline for good cause, this is not good cause, or without motion or notice if the court acts, or if a request is made before the original time or its extension expires. Courts have wide discretion in granting extensions to litigants. Good cause is a non-rigorous standard that has been construed broadly across procedural and statutory contexts. Extensions requested before the deadline should generally be granted absent bad faith or prejudice to the other party. And now she's about to do a whole explanation of why good cause exists and Lively is not acting in bad faith. Good cause exists to grant the requested extension here. Whether it is a preliminary brief on legal principles or a more fulsome fee motion, the legal issues raised by Ms. Lively's fee motions include an apportionment, if any, under Civil Code Section 47.1, in the context of a consolidated action like this one, are novel in light of this new California statute and potentially complex. I mean, they're not that complex. You should really watch some of my videos on this. And require adequate time to research and brief for the court. In addition to the extent that briefing contemplates submission of billing records and affidavits, it will require close review of complex billing records across the multiple firms representing Miss Lively in this matter, as well as corresponding affidavits from lead counsel at each firm, which is not feasible to complete on the current schedule. Can I just say, right, she's already in Texas against Jed Wallace, she has already stated how much he owes her, and she is using all the same firms. She's using the same multiple complex system of law firms. And she's already, although, she hasn't submitted any invoices, but she's already put a number out there and said, oh, he owes me $800,000. There were 2 motions to dismiss in Texas. This is just so silly. She knows what is required and she knows how much is owed. Oh, right. This is especially true given that Ms. Lively and her attorneys have a number of conflicting personal and professional obligations, including international travel. One of Ms. Lively's lead attorneys, Mr. Gottlieb, who will need to review and approve any billing submissions and sign any affidavit on behalf of the Wilkie firm, is currently out of the country. So? Oh, God, right, well, now we know. Can we have an extension, please? Because Gottlieb's on holiday. I mean, people can still do shit, across international borders. When I was working for law firms, we were dealing with international companies all the time, able to sign contracts all the time and, approve shit all the time. This is just ridiculous. Who cares if he's out the country? If he's out the country on work, he's still working and has access to his emails, etc. If Lively's trying to say, well, he's out the country and getting a tan on a beach, then, then there should be someone else who can step in. Ms. Lively has not acted in bad faith. I disagree. Ms. Lively has not acted in bad faith, and a short extension will not prejudice defendants, who will be provided adequate time to oppose Ms. Lively's motion. Ms. Lively has timely sought an extension 5 days before the original deadline of June 22nd. Thus, Ms. Lively has demonstrated good cause and easily satisfies the non-rigorous Second Circuit standard. Ms. Lively met and conferred in advance of this request with the Wayfarer parties, who objected to any effort to seek clarification or extend any deadlines, including their response deadline. Okay, so let me help Lively out here. What you need to seek, you need to compile your attorney's fees and costs for the motion to dismiss only pertaining to the defamation element. Okay? I hope that helps. You literally need to do nothing more. I would argue that she should be entitled to if you get an attorney's fees and costs for successfully defending the defamation action in the first place, then you would also bill for putting forward the motion and briefing the motion to request the fees as well. So I would say she would need to include that too. I would say that whoever, this is not like Lively should get all of this. It's the fact that she has now been awarded this. And in my experience, you would include the efforts to recover those fees as well. That's how it would normally work for any individual, not just Lively, and not specific to California Civil Code Section 47.1. But there we are. Okay. I mean, they knew this was coming, so why is Gottlieb booked a holiday for this time is just beyond me. But there we go. Okay. Do you know, I managed to stay off my soapbox more than I thought. I'm quite proud of myself. But this is stupid now. She's just acting like she's got an IQ of 47.1 at this point, and I'm getting quite annoyed with this. It feels like it's, just squeezing what PR is left in this as much as she can. I mean, I don't see why Hudson can deal with the invoicing for the P's for Manat. But if Gottlieb is unavailable, I mean, what if he gets hit by a bus tomorrow? Like, who is going to do it? We're going to say, well, we're going to, wait for him to come back and out of hospital or something. Like, if he's incapacitated, there surely must be someone else who can deal with this, who would have knowledge of all of this, access to all of the information and the documents, and can sort this out. Okay, I'm going to leave it there. Thanks, guys.